a matter with the court when it comes to, yeah.
I think that's.
Yeah, I want you to look at those.
Oh, sorry.
Oh, no, these are the wrong ones. Could be the telephone.
I have the deputies from Johnson County. Once we get to that point, I'm going to have them in uniform unless there's a strong objection, just so folks recognize that at that point there's a lot of enforcement officers who stay away from it if they're doing something. And we're going to have two Stewart County deputies in here. I know we have a large group. I expect everybody to behave themselves, but sometimes people's emotions will come up. I want to be prepared just in case that does happen. I hope deputies are totally unnecessary.
I have no objection to that, Judge. I think it's appropriate under the circumstances. Judge, we'd like to revisit one issue with the court, if we could. Thank you, Judge. Judge, I would like to go back and revisit the mistrial issue. I know it came up all of a. Oh, I'm sorry. I do. Yes. Thank you. Thank you. Oh, I need you to put that on. There's no rush to get it done. I don't need a minute, but I want to get the telephone records and make sure that we have our, so I can show it to them. You know, did I give them to you, those exhibits that we want to introduce?
Yes.
Okay.
No.
Okay, Alfredo, go ahead. We're
Thank you, Your
on
Honor.
the record, and then we are 108-817, outside the presence of the jury.
Thank you, Your Honor. Your Honor, I went back last night to do some additional research on this issue, and it has distressed me quite a bit since this happened. And I want to kind of put in a little bit different light, Your Honor, the mistrial motion. It came up, I'm sure, as a surprise to everybody and came out of the clear blue. However, I went back to look at some Iowa law on that particular issue. And Judge, when I went back and looked at it, I looked at a couple of points that I think are pertinent to our motion. I know the court has indicated that the violation was technical in nature, but I want to make my objection on the basis of the Iowa Constitution and not just the, I believe the Oregon versus Kennedy case. I could have it backwards, a Kennedy versus Oregon case. That is the kind of premier United States Supreme Court case on that eventually went back to the state of Oregon. Then Oregon looked at the case as it came back from the United States Supreme Court. And I think in that instance, they denied the new trial on the issue. And I understand the state's position that it was not intentional. And I understand their position on it, but let me put it in a different context, Judge. First of all, I believe in their initial response, they indicated they were unaware, I think maybe there was a written ruling on the motion in limine. And the court clearly pointed out there was a written ruling on it. But I think the context is a little bit wider than that. And let me explain, judges, I thought about it more last night. The issue of what we call terms of art came up specifically when it dealt with Mr. Kozak's statements. So if you take that out of the context, even with the motion in limine ruling, you still have the context of how the court and everybody working on this case struggled with his statements and what we were going to do about it. And the court took the time after it issued the ruling that was going to deny our motion to exclude that evidence to do what I thought was a detailed and acceptable to everybody's cautionary instruction to the jury. Well, this is what I was thinking, Judge, last night. I couldn't make sense of the questions. In light of the motion in limine that we filed that was applicable to Dr. High, I couldn't make sense of it in terms of the series of questions, all of them containing the elements necessary to get the first degree, particular specific intent. Well, Judge, the only sense that that question could make, having been asked outside of the courtroom, was to minimize Dr. High's testimony. Well, if that was the prosecutor's intent, to minimize his testimony, when we all knew he was not going to testify on either of those specific points, the state, after they interviewed him, after they read my statement on it, still insisted on having a 104 hearing, where they didn't raise the questions, where they did not raise the question outside of the presence of the jury. Well, when they came into the courtroom with the jury in there, and they had every opportunity, Judge, outside of the presence of the jury, to ask that question. But they waited until the jury was in to propose that question. This is the problem. To the point where the jury thinks his testimony was ill, or thinks that, in this case, Dr. High, who talks about communications. So that could have been their purpose and intent. We can't probe their minds right now, and I think it's inappropriate at this time to probe the prosecutor's mind as to why they decided to do that. But Judge, in light of how quick it came up, the only logical reason they could have had to do that at this point, and no one could reflect on the damage that was done to the defense by this statement being made. And if it, and I have a couple of cases, Judge, from Iowa, when they indicate, I believe in the State versus Johnson case, and also Sullivan's preservation of error providing a basis for appellate review, 22 Drake Law Review 435. The primary purpose of a motion in limine, as we all know, is to avoid disclosing to the jury prejudicial matters which may compel declaring a mistrial. So we alert the court, as the court well knows in this case, Judge, to the problems that we're going to have, and we did that. And in the Jensen case, 216 Northwest 2nd, 369 in Iowa, 1974, the prosecutor, even an overruled motion in limine serves as a red flag which precludes counsel from engaging in trial conduct which goes beyond principles made clear in the motion proceeding. The proper way for the state of Iowa to have acted in this instance, Judge, and we forgot to consider this yesterday, is they have to first alert the court. If she's going to ask a question like that, she was supposed to give us an opportunity to object and do that, and that wasn't even done. So it can be repaired by a cautionary instruction of that nature. And I think, Judge, a mistrial ought to be considered in light of these new arguments, and we also add that not just the U.S. Constitution, how they interpret this type of violation, but I think the Iowa Constitution should be applicable also.
Mr. Parrish, before I have a response, let me clarify some things I said yesterday.
Sure.
I said this was a technical violation. When I said it was a technical violation, I meant that this went to an issue that was touched by the motion in limine, but it did not actually violate the ruling that I issued on the motion in limine. Your motion in limine asked me to prohibit the state's experts from rendering opinions going to specific intent. When I ruled on the motion in limine, I prohibited all experts from rendering opinions going to specific intent. The questions asked of this witness did not call for opinions going to specific intent. The question, the instruction that I gave to the jury, and the fact I told them to disregard the answers, which were essentially, I haven't rendered any opinions on these issues. I appreciate you're trying to preserve error. I appreciate I might be proven wrong on appeal. I am aware of the need to provide your client with a fair trial. I think this particular issue has not deprived him of a fair trial, and I would deny the renewed motion for mistrial. Again, I appreciate you want to be sure you've properly informed me of the issues and your concerns. I believe you have done that.
Thank you.
And I understand that the appellate court might disagree with me down the road,
and I think that issue is ripe for them to decide. But I would not mistry this case because of those questions. Now, I would also stand by something else I said yesterday. We've broached this issue now, and I've cautioned the jury. I don't want to see any questions of the state's experts that touch on no premeditation, not deliberation, not specific intent. As I said yesterday, I think it would be impossible to have them render complete testimony without maybe occasionally using the word intent, but you should be very cautious of the context in which it's used. I would expect that they might use the word plan because, again, I don't think that's entirely a term of art, and we've already heard the word plan or planning from the defense experts, but we need to be staying away from the legal terms of art when we are having the prosecution experts testify today, because my view of whether this is a fair trial may rapidly change if we have the prosecution experts blurting out these terms of art. I think the cautionary instructions and the context in which the terms came up before have not deprived Mr. Kozak of a fair trial. If that context changes or we continue to refer to the terms of art, my opinion may change. In fact, I would say there's a good chance it will.
Well, I did not raise any question about plan. I believe it was the state who constantly, I think they raised it about 7 times yesterday with regard to plan. When they were questioning Dr. Logan. The other thing I would add, Judge, I think it's appropriate, since the court has denied the mistrial motion, that the court consider whether or not, based upon the questions, some type of sanction should be imposed in terms of argument, in terms of their witnesses. But I think, Judge, the questions themselves, and I understand the court disagrees with me and indicates that it was not as serious as we believe it is, but I think, Judge, in light of what has happened and our belief as how it impacts our case, I'm asking the court to consider some type of sanction in this matter that would be appropriate, that could impact the argument, because I know we disagree, Your Honor, but the argument that I believe was put forth is that it was to minimize Dr. High. And I believe an appropriate sanction should be made, because if the state gets up and argues, well, Dr. High has nothing to do with this case, you heard him answer that, even though you told the jury to disregard it. I watched one juror specifically, when you told him to disregard that, she took a pencil and scratched through the answer. Now, I could be cutting myself both ways for that, but I thought it was a powerful point in the trial. And again, I understand the court's rule, but I think it was on purpose. But the point, Judge, it's my opinion and my thought and my advocacy at this point that the court should consider some type of sanction in the course of argument or witness restriction.
I don't view it as a sanction, but the current status of my ruling on the motion would prohibit any party from pointing out Dr. So-and-so did not opine on these issues. That's not fair game for argument for either side, because I have specifically directed you to limit the experts to talking about the predicate facts and not using the legal terms of art. If I were to hear from the state, particularly argument that Dr. High admitted the answers to the questions I struck, that would be grounds for a mistrial. And I assume I won't hear that. I would be very upset if I did, because at that point we've invested as much as possible in the trial and now we've just thrown it all away. And if that were to happen, I would consider other much more serious sanctions against counsel, because that would be a huge waste of everyone's resources if we mistry the case at that point in time. I would not be inclined to otherwise limit the state's experts or arguments, except as I already have with the motion in limine. I expect that much of the argument in this case from both parties will focus on the definitions of the terms of art, because you will then have those in the instructions, and your argument as to why or why not those definitions have been met, the argument should just not extend to the fact Dr. High admitted he's not addressing those issues. Dr. Logan admitted, and actually Dr. Logan didn't, but I think you talk about the specifics of what the experts have said as far as the factual predicates. And I will allow you both to do that. I've assumed since before trial started that that would be the main thing we were talking about in this case on closing arguments, because it appears to really be the sole thing that's really an issue in this case. If you have concerns about whether your argument will be allowed, you might want to proactively address that before you make the argument, to be safe. All right?
Thank you.
Are they ready to move?
Judge, we can do this later, but we did not make the record on that. But we can do that at the break. I'm okay with that. On his.
Jeannie, can you hold them out there for a second? And move them back in the door so they...
And I apologize, Judge, for not reminding the court on that.
Let's go ahead and make the record.
Okay.
Mr. Parrish, we discussed late yesterday, it is my custom, and I believe your normal practice as well, to make a record as to whether the defendant is going to testify in a case so that we are certain that he's made a knowing and voluntary waiver of that right. At this time, I'm ready to receive any professional statement you want to make in that regard.
Thank you, Mayor, please, the court and counsel. Your Honor, prior to trial and in prior sessions that I've met with Mr. Kozak, I have in fact discussed with him that he does have a right to testify. That right is his right. It's a constitutional right afforded him by the Constitution of the United States and Iowa. I also explained to him that he could exercise that right against my advice if he wanted to, because that right belonged to him. I have discussed it with him prior to today. I've discussed it with him again this morning. We've had more than ample time to review those thoughts. Strategically, Your Honor, I believe that in his best interest not to testify. He tends to agree with me on that point. I don't think there's anything he could add by his testimony in this case other than what he said during his interview and at other points in time. For those reasons, Your Honor, we would choose not to have him testify. And I ask Mr. Kozak now, have I discussed all those matters that I've just revealed to Judge Bruns with you?
Yes, Your Honor, he has.
And you agree that you choose to exercise your right not to testify in this case, is that correct?
Yes, that is correct.
And I've explained to you all the options that are available, and that right belongs directly to you, is that correct?
Yes, sir.
You understand that, and you want to waive your right to testify?
Yes, sir.
Your Honor, thank you. In addition, Your Honor, with regard to the instruction, which we'll get to later, it's going to be our thought not to include that particular written instruction in the record. Unless the court wants to make further inquiry in regard to this, Your Honor, we would take that as our record in this matter.
Mr. Kozak, with regard to the instruction, you understand that you have a right for me to issue an instruction basically telling the jury they can't take anything from the fact that you didn't testify. It's really whether you have that instruction is a decision you and your counsel make. Different attorneys have different views as to whether it's a good idea to give the instruction. Is that an instruction you have agreed you do not want the court to give in this case?
Yes, sir.
All right. And Mr. Kozak, has, with regard to that instruction and with regard to your decision not to testify, has anyone somehow tried to influence you by making threats or some kind of promises to you or your family or anybody else to get you to give up your right to testify or give up your right to that instruction?
No, sir.
Okay, that's all I need.
Thank you, Your Honor.
All right, now you can bring him in, Janie.
All right. Sauer District Court is reconvened. The Honorable Judge Christopher Bruns presiding.
Please be seated. Mr. Parrish, does the defense have any additional evidence it wishes to present at this time?
No, Your Honor. Mr. Kozak would rest subject to us review of the telephone records.
All right.
Thank you.
Ms. Linus, does the state have rebuttal evidence it wishes to present at this time?
Yes, we do, Your Honor.
You may call your first witness.
Thank you. We call Dr. Arnold Anderson.
Dr. Anderson, if you'd please come up here.
Yes, Your Honor.
You can set that case kind of behind you there if you want, or to the side. Please raise your right hand for me. Do you solemnly swear or affirm that any testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Please take your seat, doctor.
Thank you.
Please state and spell your name for the record.
Arnold E. Anderson, Andersen.
Dr. Anderson, one housekeeping matter. Try to be sure the lawyers are done with their questions before you answer. If you talk over each other, it's impossible for us to get an accurate record, okay?
Yes, Your Honor.
Thank you. Go ahead, Ms. Linus.
Thank you. Dr. Anderson, where do you live?
I live in Johnson County, Iowa City.
Are you married?
Yes, I am.
Do you have any children?
I have 3 children. 2 are married, 2 grandchildren, 1 on the way, and a daughter who's engaged.
Okay, thank you. Could you tell us briefly what your occupation is?
I'm a physician. I have training in psychiatry, and I teach, do research, and practice psychiatry.
Okay. Could you tell us about your education, starting with medical school?
I went to medical school at the Cornell Weill Medical College in New York. I did a medical internship at the Brigham and Women's Hospital, which is one of the Harvard teaching hospitals. I began psychiatry back at Cornell, and then because of the Vietnam War, I was part of the Public Health Service for 5 years. Then I finished my residency at Johns Hopkins, and that's probably the end of education except for conferences. And
Okay. And when you did your residency, what was your residency in at Johns Hopkins?
my residency was in psychiatry.
Do you have certificates and licensures in different areas of medicine?
I'm board certified by the Board of Psychiatry and Neurology, primarily in psychiatry.
Are you a medical doctor licensed to practice medicine in the state of Iowa?
Yes, I am.
And you're board certified to be a psychiatrist in the state of Iowa too, I take it?
Yes, I am.
Thank you. Could you describe in more detail what your current occupation is, or occupations?
I have several. I'm Professor Emeritus at the University of Iowa. I teach pro bono residents and students. I see patients at the Department of Corrections. That involves, over the past 5 or 6 years, telemedicine, interviewing and assessing diagnosis and treatment of new offenders, evaluating patients for competency to stand trial. There are a few other legal matters, such as whether a person has waived their rights for Miranda. And I teach, as they ask me to, at Johns Hopkins Hospital, where I'm a faculty member. I'm rewriting some books on psychiatry as well as writing a textbook on psychiatry.
Do you have any particular honors and awards?
I have been named top doctor of the year for a number of years, but I don't keep records.
That's something that you do on a regular basis, keep record of your awards and things like that?
No. I'm a Distinguished Life Fellow of the American Psychiatric Association. I've received awards from the Department of Corrections, from various groups devoted to the care of the mentally ill.
Okay. You mentioned you are an emeritus professor at the University of Iowa. What particular department do you work in? Or
I work primarily in the Department of Psychiatry, but would be available to any of the departments on matters of consultation.
is that through the Carver College of Medicine?
Yes, that is correct.
You mentioned some of your teaching, such as at Johns Hopkins, but while you've been at the University of Iowa, were you clinical? Did you do clinical teaching with residents, medical students, et cetera?
In a teaching hospital, every new admission is a teaching case. We're expected to do one-to-one teaching on how to make a diagnosis and prescribe treatment for every patient who comes in. I give lectures on a variety of topics, such as diagnosis and treatment, on forensics, on eating disorders. I substitute for the chairman doing chairman's rounds, in which new complex cases are presented for me without knowing in advance, and I'm expected to demonstrate how to evaluate the patient and then treat them, as well as understand the origin of these disorders.
Okay. Do you have a special area of interest in terms of your research?
My research is primarily in eating disorders, but it also has been in brain disorders resulting from metabolic abnormalities.
Do you have a number of publications and books that you have authored?
I have a few hundred publications, perhaps 6 or so books.
Do you have particular professional affiliations as well?
Yes, I do. I'm Distinguished Life Fellow of the American Psychiatric Association. I'm a member of the American Medical Association. I'm a member of the Academy, a founding member of the Academy for Eating Disorders and the Eating Disorders Research Society, and I think there are a few more.
Do you serve on any professional review boards?
I serve on reviews for a number of professional journals. I have been on review committees for different departments in the Carver College of Medicine.
Do you train residents on a regular basis then?
That's been one of the highlights and joys of my life, has been training residents for somewhere between 35 and 40 years. And residents are physicians who have their medical degree but are now specializing in psychiatry.
And how long have you been training residents?
I think since 1975, but also 68 to 70.
Prior to joining the faculty at the University of Iowa, Carver College of Medicine, where did you work?
I was on the faculty of the Johns Hopkins medical institutions from 1975 to 1991.
Is that when you joined the Carver College of Medicine?
Yes, that's correct.
And what was the reason for joining the Carver College of Medicine faculty?
I was commuting 2.5 hours each day from suburban DC to Baltimore. There were increasing numbers of guns in the schools. And when my colleague became chairman in Iowa, he asked me to become director of residency education and also bring my research program on eating disorders to the Carver College of Medicine.
Is the information, do you have an updated curriculum vitae that you provided to me?
It's fairly updated.
May I approach, Your Honor?
You may.
Dr. Anderson, I'm showing you what has been marked as State's Exhibit number 45 and ask if you recognize that.
I do recognize it.
And how do you recognize it?
Has my name on it. And it has a familiar litany of education, licenses, organizations, academic appointments, etc.
Okay. Would this be the curriculum vitae we were just discussing?
That's correct.
Your Honor, I'd move to admit State's Exhibit 45 at this time.
No objection. Exhibit 45 is admitted.
Thank you. You mentioned your research area is in patients with eating disorders. Do you see patients, though, of all types of disorders?
When I'm attending physician, which up until about 2010 meant 6 to 8 months a year of being attending physician on a busy inpatient unit, I'm responsible for the diagnosis and treatment of patients with any psychiatric disorder admitted to the university hospital.
Do you have any idea how many patients you have seen throughout the years?
If I have to give a rough estimate, I thought somewhere in the 5,000 to 10,000 might be reasonable.
And that would be all types of disorders that you've seen?
Yes, ma'am.
I want to talk a little bit about your work at the Iowa Medical and Classification Center, and can you explain what the Iowa Medical and Classification Center is?
The Iowa Medical and Classification Center is the coordinating point where anyone who is found guilty and sentenced to prison first comes in for a comprehensive evaluation and treatment. This includes medical evaluation, dental, ophthalmic, psychiatric evaluation. And then people who have a psychiatric diagnosis would go on from myself or other staff members to receive the appropriate treatment. I've also done follow-up for several thousand people by telemedicine, which is a wonderful, innovative approach to areas where it's not possible for a physician to be regularly there. And then I have evaluated patients for competence to stand trial to see if there is any mental disorder which would interfere with their ability to have a fair trial. That means they have to understand what's going on in court, who's there, what they do, the charges, be able to work with their attorney, and to not have a psychiatric disorder which would interfere with their ability to take part in a fair trial.
Are you a psychiatrist certified in forensic medicine?
I'm not certified in forensic boards.
In spite of not being certified, you still work with a population to determine competency and things like that?
Yes, I do. I've done several hundred evaluations of competency to stand trial and testified in court when asked to do so.
When you began working, or in the past, have you had mentorship on performing forensic psychiatry?
I've been mentored by Dr. Patricia Westmoreland, who is board certified in forensics, internal medicine, and psychiatry. We worked together at the Iowa Medical and Classification Center for several years, and she currently is in Colorado in a combination of private practice and academic appointment. She instructed me in the basics of evaluating patients for competence to stand trial, reviewed my notes. I sat in with her, and she's given me various publications concerning how to do that in an effective manner.
Is the work that you do at IMCC in terms of doing evaluations and treatments for the patients you see either in person or through telemedicine the same as the kind of evaluations and treatments you've done for your entire career as a psychiatrist?
Well, people are pretty much the same all over, and while they may carry with them a sentence, they have the same variety of disorders. In fact, they're overrepresented by quite a bit in the prison system. A good estimate would be that at least 25% of inmates have a serious psychiatric disorder. And I'm pleased that they receive quite good, up-to-date evaluation and treatment. The challenge is keeping them on treatment once they've discharged their sentences.
In this case, were you asked to perform an evaluation, a psychiatric evaluation on Alexander Kozak?
Yes, I was asked to do so by the county assistant attorney.
Do you have any idea how we found you to ask you to do this?
I think it was fairly indirect. I have a low profile. I don't advertise. Two of my colleagues, Professor Don Black and Rob Philibert, I believe suggested that I might be helpful because of my interest in the intersection between mental health and the prison population.
Had we ever met, or had you ever met Ms. Elliott prior to your doing the evaluation, or before being asked to do the evaluation on Mr. Kozak?
I've not had the pleasure to do so.
Well, thank you. When you were asked to do this evaluation, did you do anything in terms of making sure it was clear in terms of the independence that you would use, even though you work at the Iowa Medical and Classification Center?
One stipulation that I've always made has been that my evaluations will always be independent and objective to the best of my ability, whether it pleases or displeases people. In my work as a national independent physician reviewer of disputed cases where health plans deny benefits, I've regularly overturned them. My job is to do my job rather than to worry about who likes it.
Could you explain how you conduct a psychiatric evaluation on a patient?
If there is available outside information, I try to review that. The most important beginning parts of the evaluation are to first tell a person what you're going to do, which is that I would like to have their cooperation in learning about them and then making, if it's appropriate and if it's found, a psychiatric diagnosis and then prescribing treatment. Informed consent is important. But the other thing that's most important is to demonstrate a sincere respect for the person and form a trusting therapeutic relationship in which they will feel free to disclose what's going on, because psychiatric disorders are not like coming in with a limp or a sore throat. You have to have a person trust you to let down the veil of what's going on in their mind. Then there's a very systematic approach. It varies from institution to institution, but in general, one would obtain a background from birth up until the time of the examination. That would include any birth defects or injuries. It would include the context of the family, how they were treated, any abuse, or was it kind and loving. We want to know what their education is, any difficulties in education. We would move on to their developmental trajectory. Had they had any troubles with drugs or the law? How about key relationships in their life, jobs? How they've done on them, what their future aspirations are. And then at some time, and when these are written afterwards, they're not necessarily obtained in a lockstep order. It's the job of the evaluating and treating psychiatrist to put it all together logically after, but you don't want to ask them in some lockstep manner, question after question. Then we get a mental health history. Have they had any early brain disorders, any ADHD? Have they been referred in school for special education? Any autistic features? When was the first time they were referred or sought out a mental health professional? Have they been an inpatient? Have they had spells of depression, anxiety, delusions, hallucinations, any treatment, pharmacology? And then the next would be the mental status examination. And that's how they're doing right then and there, as opposed to what brought them to this point. And based on that, not too different from going to your family physician, I would make a diagnosis and then discuss treatment options. And that might include a variety of approaches, including medications where appropriate, psychotherapy, changes in the environment. If it were appropriate, I would coordinate with family resources, with community resources, and then work out together a plan for the future. We would also inform a patient on prognosis, that is, what the future holds and how they can cope with it. My goal is not just to pull weeds, it's to grow roses and help people with resilience and with flexibility in this complex world. Understand themselves, to love themselves without excusing themselves.
Okay. Do you sometimes use psychological testing as well?
There are two kinds of psychological testing. The ones that I'm qualified to give have to do mostly with symptom evaluation. For example, the Hamilton Depression Scale or the Beck Depression Scale. Ones that involve expertise in neuropsychology or other aspects of personality, I would ask a colleague to do, and then we would go over the results together.
Did you conduct a psychiatric evaluation on Mr. Kozak?
Yes, I had the pleasure of evaluating Mr. Kozak.
And do you remember approximately when you did this? Would it have been March of this year?
It's a very, yes, ma'am.
Okay. And over what period of time did you do the evaluation?
It was done over 3 days. I find that visiting with someone over several days is more likely to produce consistency of results. And each time there's a bit more dropping of the veil and bonding and trusting sense so that we can come to a better and consistent understanding if there is a diagnosable disorder in that person.
Before you met with Mr. Kozak, were you provided with a variety of different background materials involving the case file in this case, transcripts of his interviews, the variety of other reports? I won't go through them, but all of them, but as many different reports as you could obtain from this case, this criminal case, as well as the report from Dr. William Logan before doing the evaluation on Mr. Kozak?
Yes, I had the chance to go through them all, including CDs and DVDs.
Did that include the other witnesses and other people who provided information in this case?
Yes, it did.
You said you conducted the interview over 3 days with Mr. Kozak. Did you explain to him the purpose of the evaluation?
Yes, I did. I explained it, and he said he understood it.
Okay. And what did you tell him, if you remember?
I can go to my notes for a more exact description, but basically it's that I've been asked by the Johnson County Attorney's Office to do a psychiatric evaluation, and with his permission to submit it to the Johnson County Attorney's Office.
Okay. So informing him that it could be used in this criminal proceeding?
He understood that.
Okay. And did you include that in your report as well?
I would have to look for the detailed sentences.
Would you believe it was in there in some fashion? Is that correct?
Yes, ma'am.
Thank you. When you met with Mr. Kozak, did you review his psychiatric history?
I reviewed his psychiatric history with him, as well as contained in Dr. Logan's report.
Had Mr. Kozak had any prior psychiatric history?
He had not had any psychiatric history typical of any psychiatric disorder. He had not used drugs. He had not sought or been referred to a mental health professional, and he had not been prescribed any psychiatric medications.
Did you obtain also something of a medical history that would be relevant for any kind of psychiatric conditions?
I did. In a somewhat indirect way, his unfortunate failure to enter the armed services because of an endocrine disorder is relevant, not so much for the direct effect of the endocrine disorder as it is for the psychological blow to a person who wanted to serve in the military.
So he indicated he had an endocrine problem that prevented him from serving in the military?
That's correct.
Okay.
Everyone virtually is going to have an episode of temper, but that's not a psychiatric illness.
If his wife later provided information that he lost his temper, got angry several times a day, and yet all of the other information you had regarding him having his job and other things about him, would that change your diagnosis in any way?
No, it would not.
And why not?
He did not have functional impairment. The part that sometimes is forgotten is not only to make a diagnosis, not only do you have to have signs and symptoms, it has to lead to functional impairment. For example, loss of a job, getting fired, a breakup of relationships. He didn't have the functional impairment, and he didn't have the criteria for the diagnosis. This tends to occur in young people who trouble their parents, and his history was that of having a good relationship with his mother.
If Dr. Logan also then has now provided a diagnosis of borderline personality disorder, did you find that diagnosis in all of your evaluation of Mr. Kozak?
I did not find that. If it helps to say that borderline personality is an archaic term based on a flawed, out-of-date theory of psychiatry, a better term is emotional intensity disorder.
And can you explain what you mean by that?
Of course. These are people who hate without reason those whom they will soon love without measure. So this is a person who has chaotic emotional relationships going from hot to cold, not able to appreciate in other people a variety of faults and strengths. He didn't show that. He had good working relationships. He had a number of buddies. I've treated hundreds of patients, and they tend to harm themselves, not other people.
Okay. So you didn't see symptoms of borderline personality disorder when you evaluated him?
No, I did not see symptoms of borderline personality disorder.
And if somebody is diagnosed with borderline personality disorder, would that prevent them from planning things?
Borderline personality, if we have to use that term, would not prevent a person from planning or carrying out typical goals. They're around us everywhere.
So people who have borderline personality disorder, are those people who end up institutionalized, or are they out in the community, or what kind of severity would we see with somebody with that diagnosis?
There's a spectrum of severity in borderline personality, from simply your next door neighbor to a person who comes in the emergency room with self-harm. They have dark moods in which they cannot think of anything to do other than hurt themselves. When they do come in, they benefit mostly from an intensive psychotherapy program, giving them skill sets to deal with these terrible mood swings that they have.
There was some other discussion by Dr. Logan yesterday regarding brain development, in particular in males. Was there anything you saw in particular or that you felt needed further evaluation in Mr. Kozak regarding his brain development?
We always inquire whether a person has had head injury of a severe type. For example, a loss of consciousness requiring emergency room evaluation, and then subsequent problems such as seizures. According to the record, Mr. Logan had about 5 hits on the head.
Excuse me, do you mean Mr. Kozak?
Mr. Kozak had about 5 hits on the head, and these were the typical of people growing up, perhaps being headed by a soccer ball. There was no loss of consciousness, no medical treatment, no admission to hospital, no consequences, return to normality.
Okay. So did you have any concern about any kind of brain injury or things such as that with Mr. Kozak?
I didn't have any concern about brain injury, and it might be helpful to note that no brain imaging was requested and no neuropsychological testing was requested.
And just in terms of the development of a person's brain through their lifetime, did you see anything something that would suggest to you that a male of the age of 22 wouldn't be able to plan things or?
Object to the question on planning and move that be stricken from the record. Jury disregarded. It's been asked and answered. Overruled.
Anything in terms of his developmental age that would prevent him from being able to plan, make decisions, carry out his normal activities of life?
Same objection. Overruled.
You may answer.
Considering the number of 22-year-olds we have in the armed services, to assume that they had abnormalities in brain development and had to be in a sheltered position for some indefinite time until some unknown method showed that they had perfect control would mean that everybody that age was ill.
And would that be your opinion, that everybody under the age of, say, 25?
They have no psychiatric illness. They certainly need guidance and role models to encourage them on.
And in Dr. Logan's report, did there seem to be anything that suggested that further testing needed to be done regarding determining brain development?
Well, if a person suggests not just that the fact that brains continually develop such that there's a more perfect executive control of feelings as you go on, if it was more than a general statement of what is known by virtually everybody, that maturity takes time, then a request for imaging and neuropsychological testing, if there was genuine concern, would have been mandatory.
So your conclusion after evaluating Mr. Kozak and reviewing, including Dr. Logan's report and everything, does Mr. Kozak suffer from any kind of mental illness?
I have to say, unfortunately, he doesn't.
And what do you mean by unfortunately?
I wish there was something treatable, because then the future, I think, would offer hope. I think the process of maturity...
We approach, please.
You may. Counsel, could you please ask another question?
Yes, Your Honor. And during your evaluation, you do not do any kind of treatment recommendations, is that correct?
During this evaluation, no.
Right.
During others, yes.
Okay. Did you find that he was suffering from any kind of problem with substance abuse or things such as that?
No, he had no substance abuse history.
And I believe you said he seemed intelligent, but did you notice any kind of intellectual deficit in any way?
He had no intellectual deficit. On the contrary, I thought he was quite intelligent.
And when you were talking to him, was he coherent, able to understand questions, etc.?
He was very coherent and very forthcoming about his life and his feelings and every aspect that I could ask him.
Thank you. I have no further questions.
Thank you.
Thank you, Your Honor. I just want to understand your background a little bit, Dr. Anderson. I'm Alfredo Parrish. We've never met, is that correct?
How do you do, sir?
want to start, first of all, with your experience and background. The first thing I want to ask you is, when you were describing your qualifications, I believe you indicated that you were not a forensic psychiatrist.
That's correct.
And what is the difference between a forensic psychiatrist and what you do in terms of qualification?
A forensic psychiatrist and a similar, well-trained and experienced board-certified psychiatrist are equivalent in being able to diagnose and treat psychiatric disorders. The psychiatrist who has board certification in forensics is able to understand the interaction of psychiatric diagnoses with legal questions.
And would it be fair to say that you've never taken the boards to be a board-certified forensic psychiatrist? Is that correct?
That's correct, sir.
And you've never had an interest in taking the boards to be a forensic psychiatrist, is that correct?
No, that's not correct. I have the interest. It's a matter to be done in the future.
So you're thinking about doing that down the road?
Yes, sir.
All right. So you have to do a lot of studying in order to get ready to be what's called a board-certified forensic psychiatrist, is that correct?
That's correct, sir.
How many exist in Iowa that you know of? A board-certified forensic psychiatrist?
The only one I knew has moved to Colorado.
All right. How many exist in the Midwest that you know of? A board-certified forensic psychiatrist?
I would have to look that up. Tracy Gunter was the head of the forensic residency fellowship program at the University of Iowa. She's since moved to a position at another university. And as a result, we no longer have a forensic fellowship program.
So, no, sir, and I'm sorry, doctor, if I didn't make myself clear. So you don't know another board-certified forensic psychiatrist in the state of Iowa, do you?
Not in the state of Iowa.
Do you know any in the Midwest? Can you name one board-certified forensic psychiatrist in the Midwest?
Tracy Gunter?
She's in Colorado?
No, that's Patricia Westmoreland.
Okay.
Tracy Gunter is, I think, in Missouri.
Okay. That's the only other one you can think of in the Midwest?
Of a board-certified psychiatrist, yes.
That's kind of a rare bird, isn't it?
In the Midwest, unfortunately, it is.
Okay. They're very hard to find, would you agree?
Yes.
And a board-certified forensic psychiatrist is perhaps one of it is the absolute highest achievement that you can perhaps get in the field of psychiatry. Would you agree with me on that?
Oh, I would not agree with you on that.
Okay. Well, let's put it this way. It's the most rigorous training that you can have to be able to pass the test and become a board-certified forensic psychiatrist.
I think there are other equally demanding subspecialty certifications in psychiatry, such as geriatrics and substance abuse boards.
Okay. So you think substance abuse boards in psychiatry would be just as rigorous as a forensic psychiatrist board, is that correct?
They all have very high standards, correct.
Okay.
So.
Right. And I take it at some point you were familiar with, and Johns Hopkins is an excellent institution, the Menninger Institute, you were familiar with that, I'm sure, in your practice, is that correct?
Yes, I am.
It's one of the top institutions in the world for psychiatric training and treatment. Would you agree with that?
It has a great illustrious reputation. I would have to examine closely its standing today compared to places like the Mass General and and Johns Hopkins, it may be slightly behind the times in having longer-term commitments out of proportion to contemporary psychiatry. It's certainly wonderful and well-recognized.
And so let's say 10 years ago, it had no peer, basically, right? 10, 15 years ago, Menninger had no peer in terms of it was the top. Would you agree?
With respect, no, it wasn't at the top.
John Hopkins was?
The Mass General was probably number one.
Okay.
Johns Hopkins, number two. The U.S. World Report. No critique of the Menninger. It's a wonderful, warm place.
I said 15 years ago was my question.
I would say 30 years ago.
Oh, 30 years. Okay, that's fine. 30 years ago. All right. Now, let me ask you a couple other questions about your qualification. If I understand you correct, you talked about the books you had authored. Now, would you agree that of the books that you've authored, out of the 11, I think, and I say you indicated you're working on a couple of more, 10 of them are on eating disorders. Is that correct?
That's correct concerning books.
All right. Then you wrote some abstracts. Basically, tell the jury what abstracts are.
An abstract is a summary of a presentation you plan to or have given at a national conference.
And would you agree that of the 48 abstracts that you have, in fact, given or prepared, 46 of the 48 are on eating disorders? Would you agree with that?
If that's your finding, I certainly would agree.
You don't disagree with me, do you?
Not at all.
All right. And you've also published in what's called 36 miscellaneous publications. Would that be accurate?
It's an underestimate. I don't
close.
keep track that well.
Well, of the 36 miscellaneous publications, all but 3 of them are on eating disorders. Is that correct?
If that's what the record says, I wouldn't disagree.
And you've written some book reviews. Is that correct?
Yes, I have.
And of the book reviews that you've written, they had to do with male body obsession, anorexia, and eating disorders. Would that be true?
That's correct, sir.
And you've given, what, I think you say in your CV, 214 lectures. Is that right?
Approximately.
And of those 214 lectures that you've given over your career, 200 of them are on eating disorders. Is that correct?
That's correct. That's what gets you tenure.
Get you what?
Tenure?
You've also presented panels, workshops, and what you call poster presentations as you lay out in your CV. Is that correct?
Yes, sir.
Of 62 that you referred to in your CV, 55 of them are on eating disorders or the male body image. Is that correct?
I assume it is from your reading the record.
You've also written chapters in various books, have you not?
Yes, sir.
And I think there are 56 chapters that you've written.
About.
And of those 56 chapters that you've written in books, 56 of those books or in those chapters are on eating disorders. Would you agree?
Yes, sir.
You've also appeared on Oprah Winfrey's show. Is that correct?
Yes, sir.
And when you appeared on her show, it was to talk about anorexia. Would that be true?
Yes, it would.
So there's no doubt in your mind that you're an expert in eating disorders.
I let others use that term. I say I'm experienced.
Did Mr. Kozak have an eating disorder?
He did not.
Did you ask him any questions about that?
I don't think I did.
Now, with this eating disorder background that you had, the state of Iowa hired you at some point to do work at what we call Oakdale, you call what, the Iowa Medical and Classification Center, which is in Johnson County, is that correct?
That's correct.
And you started that in 2010, would that be fair?
About that time.
And it was also at that time that you had your last lecture, and let me correct it, correct me if I'm wrong, you had your last lecture at Johns Hopkins, or have you been lectured there since 2010?
I've been there since then.
How many times?
I haven't kept track. A few.
2 times?
Let's say 2.
All right. Since 2010, that's what, 6 years? Is that right?
Correct.
And you're paid by the Department of Corrections, are you not?
Of the state of Iowa, I don't know beyond that.
Well, it's in the Department of Corrections, that's where Oakdale is, isn't it?
As far as I know.
Right. And they pay you.
They do?
And what do they pay you?
Somewhere 150 plus, somewhere between 150 $168 an hour.
168 per hour, did you say?
Mm-hmm.
Is that a yes?
Yes.
Okay. So,
My wife gets the money, I don't.
okay. Well, that's true in just about all of our households, so.
So
You're not telling us anything we don't know about that, okay? So, let's move on from there. That can be a sore
Sure.
subject for people. All right. So, they pay you by the hour, is that correct?
That's correct.
And so they pay you based upon the number of evaluations that you do for them?
It's by the hour. I make the decision on the time for each evaluation.
So the state pays you to do evaluations for them also, is that correct? State paying you now?
I suppose so. I show up and do my job.
And how much did you charge per hour for this?
I said whatever they want. It's a public service.
Okay, so they pay you for public service for the state you've been working for 2010, and you know the state's prosecuting this case, is that correct?
That's correct.
All right.
And they pay
And
me for my time. That's correct.
Oh, yeah. And you bill your time out at $168 an hour, you say?
I don't bill anything. I just tell them how long I worked, and they decide what to pay.
Is that the same way it works for the state at the Iowa Medical?
Yes?
You just tell them, look, I worked so many hours, here's my bill, and you expect the state to pay you, is that right?
No, I just check in and check out, and whatever happens beyond that, I don't know.
You don't send them an invoice or anything?
No?
Well, what did you make from the state of Iowa last year?
I don't know.
Roughly?
Probably $50,000 or so.
Okay. And so for in 2016, what have you made from the state?
I don't know. There's a budget cut, so they'd asked me to cut down to 8 hours a week and whatever that, but I put in whatever I think is necessary.
So there's a budget cut in the department you're working where you evaluate folks at Oakdale, isn't that true?
That's correct.
And they've had to cut down the number of people who do the same type of work that you do, isn't that correct?
They cut the hours rather than the people.
And so therefore, are you trying to do more work with less hours, or how do you speed up that process to evaluate people then down there?
I do as much as they ask me to do.
Okay. So when they told you to cut down your hours, you would agree that if you get work like this, like you're doing right now, with your background, you can increase your income.
No, I don't need this.
You've acknowledged, I believe, and correct me if I'm wrong, that what you're doing in terms of evaluation, you had to mentor someone to help you, and that's the Westmoreland doctor who's now in Colorado?
That's correct.
So someone else had to teach you the ropes in order for you to be able to do what you're doing now?
To do it well, yes.
All right. And you would agree that in teaching you the ropes, you've only learned to do this in a prison setting. Would that be a fair statement?
Perhaps you could tell me do what?
The evaluation that you were doing for the state of Iowa that paid you $50,000 last year, that is a prison setting. Would you agree with me?
That is a prison setting.
Right. Have you ever evaluated anyone from the state of Iowa outside of a prison setting?
All the time.
Excuse me?
Yes, all the time, at the university.
Evaluated people in a criminal case, and I probably didn't say that, but let me re-ask that question. You've answered that one, so let me ask it this way then. I apologize for not making myself clear. Have you evaluated people for the state of Iowa in a criminal case outside of a prison setting prior to this?
Okay, for the state of Iowa, for a criminal charge, no.
This is the first one, would you agree?
That's correct.
Now, if this is your first one, would you agree that you never once contacted me to ask me to provide you any information?
That's correct.
Did you think about that?
I did not.
Why not?
Because I thought I had adequate instruction from the Johnson County attorney and the assistant attorney.
Well, did they tell you not to contact me?
They didn't give me any instructions beyond asking me to do a thorough evaluation.
Well, a thorough evaluation, as you've already said in your introductory comments to what you do, a thorough evaluation, as you outlined it, is to get as much information from as many sources that you can get. Would you agree? That's what you said in your introductory statement about how you conduct an evaluation.
As many sources as I think you can depend on.
Are you telling me you couldn't depend on information I would provide you?
I would have a jaundiced view.
All right, tell me what the jaundiced view would be.
I think you're here to do an excellent job of defense.
Well, if I'm doing an excellent job of defense and your job is to reach a medical conclusion, why would I not want to provide you as much information to assist you in reaching the correct medical conclusion consistent with what you outlined to this jury as to what you would like to have?
I can't say.
Right. You indicated when we first started, you'd never met me before, is that correct?
That's correct.
Right. And you outlined what you needed, and you said background from birth until time to the present time, context of the family, education, difficulties, development, problems with the law, future aspirations, all information that you would get to help you as a psychiatrist come to a diagnosis, is how you put it. Is that correct?
That's correct.
Right. Now, did you get all of that information hand-carried to you by the state of Iowa?
Yes, I did.
All right. Did you get any information from Mr. Kozak's family?
Through Dr. Logan's evaluation.
Well, other than that, anything else?
No, I found that sufficient.
Did you get the full information from what Dr. Logan had gotten from the family including all of his interview notes?
I thought his summary did the essentials.
Did you understand my question?
Perhaps you could rephrase that.
Yes, sir, I will. Did you get all of his interview notes from his interviews with the family?
I did not get his primary notes handwritten.
You made the statement toward the end of your direct examination that Mr. Kozak told you, from what you could determine, he had no issues with regard to work. Was that your testimony?
I didn't say no issues.
Well, what issues did he have with regard to work then?
He was cautioned one time about not approaching Ms. Farrington except in a work context. He was also cautioned that he might want to use better judgment in brandishing a pepper spray when there were some disruptive kids who needed some chastisement at the mall. These would seem to be not great or more than other people his age and background might occur.
And that's all you know as you sit here right now?
That's all that I know, sir. But I certainly won't take into account your teaching. Thank you.
Were you aware, sir, that Mr. Isame, and I may be pronouncing his name incorrectly, indicated prior to this shooting that he was going to terminate Mr. Kozak? Were you aware of that?
Your Honor, I'm going to object. That's a misstatement of the record.
Sustained.
Were you aware that he said he was going to terminate him in the event another incident occurred with regard to Ms. Farrington?
Objection again, Your Honor. I believe that this is a misstatement of the record as well.
Overruled.
I believe I was aware, and that would be pretty normal, to say that a person's future behavior would determine their continuing job status.
But first you indicated you were unaware of that, and now you're testifying a moment later that you are aware of that. Which one is it?
I don't believe I said I was unaware. I wasn't asked that question before.
When I asked you to list the things that you were aware of with regard to his work, you didn't list that. You said there was one warning before with regard to and matter, and that was the pepper spray, and then there was one other matter with regard to another incident. Those were the two things that you mentioned.
Those are the two that I mentioned.
Did they occur at the same time?
Excuse me?
Did they occur at the same time?
I'd have to go back and look at the record.
Well, what about what you just testified to?
I'm a bit confused by the question.
All right, you testified, I said, name anything with regard to the work that you recall.
Mhm.
You then laid out those two matters. I asked you, did they occur at the same time?
I don't have that knowledge right now.
Would it make a difference if they occurred at different times or if they occurred at the same time?
I'd have to think about that.
Okay. Were you also aware as to who the person was he was advised to stay away from?
Yes,
Who was that?
Ms. Farrington.
Did you gather any information with regard to his relationship with Ms. Farrington?
Mr. Kozak was very candid about his relationship.
I'm sorry if I didn't make myself clear. Did you gather any information with regard to his relationship with Ms. Farrington?
I gathered information from him and from the cell phone records.
And that would be the text messages, is that correct?
That's correct.
And did you read those?
I read the ones that I had available.
And do you know what did they date back to?
I don't have the exact date.
Okay. Do you recall what they've dated back to?
I would have to look at the records.
Okay.
Several months at least.
And that's fine. Several months?
I think he said perhaps early in 2015, but I would have to go and look.
And did you make any assessment of that particular relationship based upon the records that you looked at?
Yes, I did.
And what was that?
There was a very intense emotional relationship with estimates of up to 20,000 texts back and forth. There was a limit on the amount of contact, I think consisting of 2 hugs and a note on the windshield.
Did you know at the same time that he was having issues with work, that in fact they continued to communicate, and one of the issues with work was his contact with Ms. Farrington? Were you aware of that?
I think that's a concern of everyone doing their job and simultaneously keeping up a massive texting.
And based upon that analysis, did you know whether or not that could impact someone in terms of their mental state?
Mrs. Kozak certainly, well, perhaps I can ask at what time. Texting is now the current method of bonding in most young people. And so there was a variety of on and off relationships through the texting, some flirtatious, some everyday events, some very emotionally intense.
And did you reach the conclusion that there was some bonding based upon what you saw in those text messages?
There appeared to be intense emotional bonding.
You indicated on direct examination that you didn't see anything. First, we talked about the loss of the job, and now we're going to go to the text message where you have acknowledged that there was a relationship, but you said you didn't see anything when you talked with Mr. Kozak over those 3 interviews regarding the loss of a relationship. Isn't it pretty apparent from the text messages that there was a loss of a relationship there that you now acknowledge was a bonding that took place through text messaging?
Your Honor, I'm going to object one. I think the question is...
That's a compound question. I withdraw it. Let me ask it this way. I apologize, but I have 2 questions in there. The first question is, you've acknowledged that there was bonding in that relationship through the text messages. Is that correct?
That's correct.
You also, in direct examination, said that in your interview with Mr. Kozak, there was no loss of a relationship. Did you not say that?
No, I don't believe I said that.
Okay. Then maybe I took my notes down wrong.
There certainly was a loss.
There's no doubt now that you acknowledge there was a loss of a relationship. Is that correct?
Absolutely.
You would also agree, Your Honor, do you want to keep going here?
For a few minutes, yes.
Okay, thanks, Judge. Would you also agree that with regard to his spouse, you did not interview her? And I'm talking about Mr. Kozak's spouse.
That is correct.
Did you have any interest in interviewing her?
At that time, I didn't think it was either necessary and might pose an emotional burden on her.
Emotional burden on her?
Mm-hmm.
Is that a yes?
Yes.
So if you had not thought that it would impose an emotional burden on her, you would agree you would have interviewed her?
Yes, I might have, and I certainly will in the future.
And you would agree that it would have been helpful for you in your analysis to see what was going on in this marriage that had just taken place September 4th of 2014, with this incident happening on 2015. That would have been important to you in ordinary circumstances.
It could be.
Okay. And you would have wanted to know how he treated her, how he interacted with her. That would have been important to you, is that correct?
That's correct. I took his word.
Okay. Now, you also reached the conclusion, I believe, in your report that there was no malingering, is that correct?
That's correct.
Would you briefly explain to the jury what you mean by the fact there was no malingering?
Malingering means imitating a psychiatric disorder, usually for monetary reasons or to get out of military service or to get a job disability. For example, someone might come in and imitate the symptoms of multiple sclerosis, but he had no signs of malingering. He was candid and thorough.
And in being candid and thorough, that helped you to some extent, at least from your perspective with the information you had, to reach your diagnosis, is that correct? The fact that he was candid.
That's correct. I was appreciative of him.
But you also saw that he had been teased a lot during childhood, is that correct?
He had been teased a lot, would require some quantification.
Okay. Let's just say he was teased for being short.
He was teased for being short, as most short men are.
And you would also agree that you found that he had a disappointment because of this condition that he had, and you couldn't get into the military, and I believe you put that in the form of, I think you called it psychological blow, is what you called it?
Yes, he would have been an excellent member of the armed services.
But you term this disability as an endocrine disorder when you were asked on direct examination. Could you explain what that was, please?
Well, I was trying to be a bit delicate. He had a testicular problem.
What was the nature of it?
Well, at first, there was a hydrocele, which is an enlargement of one of the vessels, but then it was later found, as happens often, to be malignant, and so it was taken, it was removed.
And this issue that he had, this hydrocele, you would agree was an issue that he's dealt with most of his life?
He's had to deal with it.
But you also, did you put down that he was given testosterone when he was younger?
I believe so, but I would have to go back to the text and see.
Did you make an analysis as to what impact that had on him?
I did not analyze that.
You mentioned that borderline, oh, strike that. Let me go back for a second. Did you look at Dr. Kotler's report?
I have not seen Dr. Kotler's report.
So at this point, let me ask you, have you been advised as to whether or not he's in agreement with what you found? Do you know one way or the other?
In the brief interaction in the library this morning, he said he was in substantial agreement that Mr. Kozak had no psychiatric disorder.
Okay. He said substantial agreement. Did he say he agreed 100%?
Your Honor, I'm going to actually object at this time. It's calling for hearsay. jury will get to hear from Mr. Copeland.
Sustained.
So you had a conference with Dr. Copeland before you came in here?
I did not have a conference. I was present while the county attorney was discussing with him his testimony.
And you sat through that meeting?
It wasn't a meeting, it was perhaps a 5-minute overlap.
Well, in that overlap, you were both experts sitting discussing testimony that's going to come into the courtroom, is that correct?
We didn't discuss with each other.
You just told, sir, that you indicated what he said to you about his testimony, did you not?
That's correct.
So did you hear him say that he was in substantial agreement with you?
Objection, Your Honor, then it calls for hearsay.
Sustained.
So you didn't see his testing, did you not?
I did not.
You did not read his report, is that correct?
That's correct.
Do you know whether or not he saw your report?
I don't know.
You indicated on direct examination that the idea of the concept or disease of borderline personality disorder is a bit antiquated. Is that your testimony about that?
No, that's incorrect.
How did you term it then?
What I said and I teach is that the term borderline often has a negative connotation. A more accurate term is emotional intensity disorder, because the term borderline refers to an out-of-date concept that the person is on the borderline between neurosis and psychosis.
What does the DSM-5 refer to it as?
It uses the term borderline personality and goes on to describe emotional intensity. DSM-5 is not wholly writ, and I'm quite free to disagree with it in terms of its terminology.
So you would agree that other experts can disagree with the DSM-5 also. Would you agree with that?
Yes, sir.
As a matter of fact, it's basically a treatment. It's for treatment, is that correct?
I believe its first purpose is for billing.
For billing.
Yes. And its second purpose is for epidemiology, so you can count noses. How many people, for example, why the increase in autism diagnoses? It's done by worthy, sincere people, but it tries to make too narrow and rigid the diagnoses and excludes a more comprehensive approach. It's not without merits, better than the chaos of 30 years ago, but it's not to be taken as holy writ.
That's what I was going to ask you. It's not the Bible.
It's not the Bible.
And psychiatrists can disagree about the language that's contained in there. Would you agree?
They certainly can disagree.
As a matter of fact, they should if they have an opinion that's different.
It depends. Some of its wording for certain diagnoses like schizophrenia are quite good. There are popular diagnoses such as menstrual-related mood disorder that come and go, and thankfully any stigmatization of gay and lesbian orientations was taken out some time ago. So we have to distinguish between the fairly good descriptions of criteria for major psychiatric disorders and those that seem to have a popular upsurge and then a decline.
And that was your conclusion, that Mr. Kozak had no major illness, is that correct? That was your medical opinion.
That's correct.
But you found that he had antisocial personality traits, is that correct?
A trait is not an illness.
No. My question was, you found that he had, your psychiatric diagnosis, sir, was that he had antisocial personality traits, is that correct?
That's correct.
And you also found that it started when he was about age 15.
He showed some antisocial traits. One can't make the diagnosis at that age.
As a matter of fact, it's hard to make the diagnosis unless someone has a prior conviction. That's the standard you use out at Oakdale, isn't that right?
Conviction?
If they have a prior conviction of a crime, that's where you start a diagnosis.
Not at
Oakdale, don't you?
all. Not at all.
Right. And what you indicated with regard to this is that he had a lack of remorse. Is that what you found?
Correct.
You found that he was deceitful.
He was deceitful on specific occasions. In many occasions, he was not.
And you said he lacked empathy for how others feel as a response to his behavior. Is that correct?
I was not able to appreciate in the case in question that he had a sense of how his behaviors, or actually the behaviors that Ms. Farrington said creeped her out, how his behaviors might be viewed as unwanted or unpleasant by others.
Well, an appreciation, did you see what she said specifically creeped her out? Did you look at that?
I'd have to go back to the specifics. I believe it was the note under the windshield.
You know what the note said?
I don't. Was that, I don't know if that was about the concert.
Did you make an inquiry about it?
I'd have to go back to my written record and see.
And you added a term, or freaks them out. Is that correct?
Well, that's what I saw in one of the records.
Was it a record from Ms. Farrington?
I can't tell you.
You also added, with regard to variation of details where some others reporting the same event with basic consistency, my question is, did you get any other information from any other source of his employers to interview them for this, from his family, from people who worked with him and were his friends, or from his spouse to assist you in making your diagnosis?
I used the information given to me in the extensive records provided by the Johnson County Attorney of the accounts of others. I did not reach out to those individuals.
Thank you, Doctor. I don't have any further questions.
Ladies and gentlemen, we're going to take our morning recess now. We'll be in recess till 11 o'clock. During the recess, please remember your admonition. Thank you.
The response, I believe, was unfortunately, and the doctor at that point goes into a treatment plan, which I think he basically turned into an advocacy role with regard to the state. He works at the prison. He only sees inmates at the prison. That was his point of authority. It was a question that was not even asked of him. It was his response, actually, that gave it, in all fairness to the state. I don't believe they asked for that particular question. And I think, Judge, that his indication as to a treatment protocol down the road was inappropriate, had no bearing on any issue in this case, and it should have been stricken from the record.
Ms. Melendez?
Mr. Honor, I believe the question was something that, to clarify whether Mr. Kozak suffered from any mental illness, and I think the answer was something like, unfortunately, the defendant did not suffer from mental illness. Protocol of what would happen then or what he could get, that is not prejudicial to the defendant. It's just explaining kind of what would happen. Certainly the state wasn't anticipating exactly what his answer was going to be. We were requesting further clarification on what his finding was on a diagnosis, but I don't think anything he said was so prejudicial or was really prejudicial in any way to the defendant. And we would ask that the court overturn the motion for a mistrial. I think that if you want, I could certainly have him clarify and redirect in terms of anything that the court thinks was improper. I don't think anything was said that was so improper that it warrants a mistrial.
I have in front of me the draft transcript, and I recognize it's only a draft, so it may be subject to revision by the reporter based on the notes, but it indicates the initial question was something to the effect of, so your conclusion after evaluating Mr. Kozak and reducing, this is including double report, which can't be right, and everything, does Mr. Kozak suffer from any kind of mental illness? The answer, I have to say, unfortunately, he doesn't. Question, what do you mean by unfortunately? Answer, this is all that came in, and this comports with my memory. I wish there was something treatable, because then the future, I think, would offer hope. I think the process of maturity, and then Mr. Ferris jumped in and asked to approach, the witness didn't say anymore. I don't think he actually got into a treatment plan. I told you both at the start that I have a fairly extensive psychological background. My reading of the answer is that he's starting to say that if you had a mental illness, we could treat you. You don't have a mental illness, we can't treat you. But maybe my reading is wrong.
I think, Judge, the point on this, first of all, future goes to punishment in light of the structure of this case. Second of all, he's telling the jury that he doesn't have something that can't be treated, so he's basically handing convict this guy. I mean, I know you don't read it like Judge, but I'm an advocate for Mr. Kozak. I think sometimes we see things, and hopefully, in light of all these psychiatrists, it's not paranoia. But I think, Judge, sometimes when you think people are chasing you, they actually are. So my thought, Judge, is that if you look at it from the perspective of what he said and the context of it, I keep trying to emphasize the context in this case, and sometimes we mix apples and oranges. The context of the case is he's telling them he works at the prison. They're saying, you know, this guy didn't do anything. I'll see him down the road, and he alluded to that again in his cross-examination with May.
Well, if I didn't grant a mistrial, Mr. Parrish, is there some instruction you would want me to give the jury?
I said I don't think it was invited by the state, quite frankly. I don't know what we can do, Judge. I want to think about it a little bit. But again, in all fairness to the state, they didn't ask this question.
And I appreciate your view of it. I said in the sidebar, I see this as really not having caused any significant prejudice to the defendant. Again, as I said on the previous motion for mistrial, perhaps you will show me wrong on appeal. If there's some instruction you wish to have me give, I would consider that. I would hesitate, however, to draw the jury's attention back to the statement itself. I don't think the statement is particularly troublesome because it was stopped before he provided any further detail. Had he gone into a treatment plan that he expected to give the defendant at the prison, maybe he would have a problem, but he doesn't do that. And again, he's saying, all he says is, I wish there was something treatable because then the future, I think, would offer hope. And then he says, I think the process of maturity, and that's as far as he got.
Right.
And the prior question had been about the maturation of his brain and whether neuropsychological testing might have been in order if someone thought he had a brain abnormality. That's the context of the question. So I deny the motion for mistrial. Any further record either of you wishes to make at this time?
Oh, go ahead.
Yeah, no, Your Honor.
On the hearsay objection, Judge, as I understand the posture, correct me if I'm wrong, that they were having whatever you call it, a brief session, and experts are sitting in. On Iowa law, I think experts can even sit, as I'm sure the court in the state's well aware, through the testimony of each other. That's one of the quirks of our rules. They were sitting there having a meeting. They discussed the results of the test in their testimony. That's not hearsay on the Iowa rule. These are two expert witnesses sitting there discussing what they're going to do. I'm allowed, I believe, Judge, to ask this witness what he said. If he said he was in substantial agreement with it, I'm entitled to ask him what he said to him, and if there was some disagreement, what that might be. We're talking about expert report.
You show me the part of the hearsay rule or the exception that a statement made by the expert who isn't on the stand falls under.
Well, Judge, there's a discussion they're having as experts in a case, which I believe is, that in and of itself is the exception. The expert can sit through that's what they base their opinions on. They sit through the trials, and then you can ask them, what did you learn during the trial that, in fact, influences you in any way? That's an opinion that was offered to him in the course of his testimony that relates to what Dr. Copeland said to him.
But you're not asking him what he based his opinion on.
I agree.
You're asking him what someone said to him during a meeting, and it appears to be you want to offer the out-of-court declarant statement for the truth of the matter asserted.
Exactly, because it's an opinion that he offered to him that's not in any report. The opinion is it's in substantial the same as what his opinion is. They are not the same because Dr. Copeland disagreed with him. And if he made an out-of-court statement indicating that they were in substantial agreement with it, that is inconsistent with his report. And it's not hearsay, Judge, in the classic sense of hearsay.
Well, and again, explain that to me, because I'm not tracking with you. It seems to me to be classic hearsay for the purpose you're offering it.
Right. It's an opinion. It's an opinion. And it's not just an out-of-court statement by any witness. It's an out-of-court statement by an expert.
But the rule doesn't accept out-of-court statements of experts.
If the statement is being for the purposes of testimony related to their opinion.
Well, let's take a 5-minute break. You take a look at the rule.
I will, Judge.
And maybe I'm just not following you. If you can show me what the basis in the rule for your position is, I'm happy to hear it.
Thanks, Judge. Thank you.
You're going to work 5 minutes? Okay, so let's make that at least a 10-minute break.
Okay. Seems to me like he's offering an opinion that is substantially in agreement. That's an opinion. That's not speaking. Oh, go ahead, get to it. He's offering an opinion that is in substantial agreement. He's the two experts in it. I think it's really substantial. It's really important in this case because we're talking. Yeah, this thing, it goes in and out all the time. And Dr. Logan's already testified, so they're discussing an opinion. That's hearsay. It's like hearsay. Hearsay expert.